Oh, welcome back. This is the Only in Miami show, and I'm your host, Grant Stern. You can find me on Twitter at Grant Stern and everything about the show at www.onlyinmiami.co. iTunes, podcast, SoundCloud, and a whole lot more. Check it out at onlyinmiami.co. And we're back live with Senator Rene Garcia. Senator, thank you for joining us on the program tonight.
Hey, Grant, I'm excited to be here. It's my first time, and it's great to talk to you.
Well, we've got a lot to talk about. You introduced a bill. It's called SB 1220, and the goal of the bill is to end mandatory attorney's fees for those who have sued to enforce the Sunshine Law and won. So please explain to our audience your rationale for introducing such a bill.
Yes, Grant, I think there's a lot of misconception on the bill and what the bill is trying to accomplish. I think a lot of our friends in the press are saying that this will end the access to Sunshine, well, end the Sunshine Law.
Well, that's right. That's what they're saying. But why did you introduce this bill? What spurred you to act?
No, Grant, number one is, first of all, and there's a cottage industry that has come of age where there's certain attorneys that are making a livelihood of suing local governments, not-for-profits, state governments, for public records requests. And in current statute, right now, if the government is found breaking the law, I'll summarize it. If the government is found to have broken the Sunshine Law, only then is it responsible for paying attorney fees. That's the current law. Right, and what we're trying to amend with this bill is to ensure that a judge has the discretion that if a government entity has broken the law, that they will be responsible to pay for those fees. If it's shown that if an entity, because of if they comply within the request within a reasonable time period, and the judge can say that the government entity or not-for-profit has responded to that request in a reasonable time period, then they're not mandated to pay for those fees.
Yeah, but that's how it is already. If the government doesn't reasonably deliver the record, then they've broken the law. They have to pay. If they did provide it reasonably, then the judge can rule that it wasn't an illegal act and they don't have to pay, right?
I'm sorry, Grant. I didn't hear you. Can you repeat that?
So the way that it works today is if somebody goes to court and the government says, the judge says, city government, for example, you guys reasonably, complied with the request. Even though it wasn't a very good job, it was still reasonable. The city or entity that sued wouldn't have to pay. That's how it is right now.
No, the way that it works right now,
mm-hmm.
if anyone comes into a municipality, comes into a local government, and they make a litany of different requests, of public records requests for this individual municipality, and the municipality is not able to respond within whatever the timely manner,
reasonable manner, reasonable
by law right now, they're entitled. It's a mandated attorney's fees that have to be paid by that entity.
Okay.
And by giving the judge the discretion, then the judge can take all the circumstances in that case to make sure that it wasn't an unreasonable request. And the reason that this happens is that what's happening at the end of the day is...
So who is this cottage industry? Hold on. So you've mentioned a cottage industry. So who are these people? Name them, please. I want to know who is this lawyer? Who's the guy?
No, there's a lawyer that in Broward County.
What's his name?
I don't have their name, and I can find out. I'll get you the name for you. I don't have their name, but I'm telling you what's happened when I've talked to local governments and they've explained to me the situation that they're seeing in their county, in their communities.
So wait a second,
because at the end of the day, this is taxpayer money is going out to pay these attorneys.
Yeah, but this is taxpayer money that's going to pay to create these public records. Why not introduce a bill like automatic sunshine, saying that public entities must release immediately all public records that are not exempt for some other reason, period? Then there would be nothing to sue over, right? Wouldn't that solve the problem too?
Yeah, but at the end of the day, you have to understand when there is a public records request made on any of these entities,
it does take time to, depending if they have to redact the information that's on there. Some of these individuals are asking for information that goes back 5, 10, 15 years, and it takes time to gather all this information.
Yeah, but the law says it has to be reasonable, so that's very flexible, right?
Of that municipality.
Yeah, but isn't the word reasonable enough to give flexibility? If somebody says, I need 15 years worth of documents, the agency can respond within a day or two and reasonably say, this is going to take us a while. Let us deliver some now, and we'll keep working on it. We'll make a schedule. That's all reasonable, isn't it?
But what happens now is that because of the way the statute is written, if they don't comply, they don't turn over that information, then the attorney can go ahead and file that lawsuit within a couple of days.
Yeah, but
and that's the problem that you have. If you look at
but that's what the statute implies. That
if you look through our statutes,
okay, I will.
There's more than 100 cases where it states that attorneys' fees may be awarded. This is one of the few ones that it doesn't say that attorney's fees may be awarded. And this, at the end of the day, is your tax dollars that is going to pay these attorneys who are living off.
No, wait a second. Let's be clear here. These are our tax dollars going to cover for the mistakes of government employees who break the law. The only way that these attorneys can possibly get paid is if a judge finds that a government agency is breaking the law. Correct?
And nowhere in my bill does it say that a judge cannot impose these attorney's fees if they find out that a government entity has violated the Sunshine Law.
So let me ask you this question.
Fact, it gives them a 5-day notice period. It gives them a 5-day notice period to ensure that they comply. And if they don't comply, the attorneys can still file a lawsuit in breach of their responsibility, judiciary responsibility to the taxpayers.
Okay. Have you ever had a public records request denied?
Have I ever had a public records request? I haven't never submitted a public records request.
So if you have never submitted a public records request, why do you think that this is going to help people who do submit these requests regularly?
At the end of the day, what we're trying to accomplish here.
Wait a second. No. You've told me something here. You have never created one of these requests, so I have to keep asking you, have you ever retained an attorney on contingency? Like on a contingent fee basis?
Grant, there's in our statutes right now.
Yes.
There's over 100 scenarios where it says that the judges may award attorney's fees, and there hasn't been a lack of attorneys to take on these cases to go after government entities.
Oh, I hate to tell you, that's not the case. I had an attorney to go after a government agency in a zoning fight here, and I couldn't even get him to sue for a public records case because he didn't want to antagonize the city. He was afraid to antagonize them, and he wouldn't take the case.
That's a different situation right now. But you're telling me that under the same current law, the current law that exists right now, you're telling me that he didn't take a case because he didn't want to antagonize.
That's how difficult it is with the current law. Just imagine if you take away the contingent fees basis for these cases to be hired. It takes a lot of money to fight a local government. I live in a city with 28 lawyers on staff full-time. I have no lawyer on staff full-time. And if they deny my request, well, my only recourse is to spend $500 and get an attorney involved, period. There's no other recourse.
So then, but the recourse is still there if you know you have a valid case.
But then if I have a valid case, what if the judge just says I don't want to pay fees?
Or the entity is breaking the law, then you can go to an attorney, and if you have an attorney that realizes that there is a problem, they know they're going to win the case.
Oh, well, who's going to pay the attorney? Yeah, but who's going to pay the attorney if that's the case? My government, who I'm paying taxes to.
The one that's going to pay the attorney the same way that the system works right now. The attorneys will be paid by the municipality. Those contingency fees or those attorney fees will be paid by the
But your bill would end that. Your bill would make it discretionary. Well, your bill would make it discretionary. Totally discretionary. Up to the judge. Judges can decide anything they want if they have discretion, can they not?
But if it's what's good for the goose, it should be good for the gander. If that's the case, why is it that a lot of our attorneys and a lot of our friends in the legal community have always fought to have had to give judges discretion?
In mandatory minimum sentencing, judges should have discretion, but in healing a citizen for the acts of government, discretion is not so warranted. I mean, we're talking about an act of government where government violates our Florida constitutional right. It's a Florida constitutional right. Don't you think that this risks
discretion to award those attorney fees if they see a violation of the Constitution? Nowhere in the bill does it say they don't have that right.
Yes, but
they still will have access to the public records.
Look, even having a 5-day
access.
notice. I'm going to read to you from the Florida 119 statute. It's 119.11. Whenever an action is filed to enforce the provisions of this chapter, the court shall set an immediate hearing, giving the case priority over other pending cases. Why do you think that is? Why is that not in every bill?
That doesn't change in my bill.
It does. You say you have a 5-day notice. That means you have to give a 5-day notice, and after that, maybe you can get an immediate hearing. I mean, we're talking about a serious situation where public records can be altered before they're delivered to citizens.
But let me ask you this: what happens when a public records request is done at a lower level clerk, and that information never works up its way to the appropriate hand?
Well, then obviously that government agency is breaking the law by policy. No, that means that
attorney to sue, right?
You know what? That means that the government agency is breaking.
What we need to do is make sure that we're clear as to who the custodian of public records is, so the request can be done. Make it clear. I'm willing to amend the bill to make sure that we're clear as who is the custodian of public records.
Well, anybody who has custody of a public record is required to comply with the Sunshine Law, including designated custodians. But furthermore, I would like to know, are you a trial attorney?
Absolutely not.
Okay. Are you familiar with the Florida court system's method of sanctioning? No, I'm not. But I do have to I do unfortunately have to retain attorneys to get public records from time to time. And there is a mechanism in place for people who are frivolously litigating. It is called the 57105. It's another Florida statute. And it's something that keeps frivolous cases out of the court system. Why isn't that enough to keep people from filing frivolous litigation?
How difficult it is to invoke that statute. It's very difficult to invoke that statute. I've had constituents time and time again when they've had when they've tried to invoke it and they haven't had any success. So that in itself is not an argument. I don't think it's a valid argument as to why not ensure that you give that 5-day notice period to the local entity, the local government, to the government entity, to ensure that they know that they have to submit that paperwork on time.
So you've never you've never seen public corruption. You've never seen a document altered before it's delivered because there's been a delay.
But that in itself should never happen.
It should never happen, but unfortunately we're all people. It does happen. I'm going to take one call here because we did get a call in.
Regardless if you have this 5-day notice period or not, people will still alter it, and that'll be up to a judge, and you will have to file your lawsuit.
Well,
my bill does nothing to help or deter or prevent that as well.
It absolutely would.
You're talking about it's happening today with the current bill, the current law.
It happens all the time. I'm going to take this call because we got a call from our tweets. Caller, name and city.
Eric McDonough, Homestead, Florida.
Eric, what's your question for the senator?
I'm just really confused here. Right now, the way it is with shall provide the attorney fees provision, if I hire an attorney to file a public records request and the city or municipality is found to be in violation of the law, I'm guaranteed to get my attorney fees back. No questions, ifs, ands, buts about it. If we convert it to may pay attorney fees, I think that gives the judge too much discretion. For any reason, the judge could decide not to give you your attorney fees. I've had a lot of issues with public records myself, and trying to find an attorney to do these under contingency is near impossible. When I've gotten attorneys to do this, I've had to pay them retainers up front, and they were reduced retainers of several thousand, but they were still required just because, the attorneys would do that. If there was no shall pay provision in there,
what's your question?
I'm not sure anybody but the wealthy would be able to get representation or get help in these cases.
So what's your question for the senator?
The frivolous law, if somebody files a frivolous lawsuit, they can already be countersued. Why aren't we using the laws we already have on the books versus gutting, rights that we have under the Constitution?
Okay, so that's a good question. Why are we not using the laws that we already have on the books?
My understanding that in these public records law, you can't countersue. So that's one of the issues that we have.
Why is that?
Listen, I really don't know. I'm not going to sit here and try to argue and be like a politician. I really don't know what the answer to that is. We can find out for you. But at the end of the day, what I'm trying to make sure that we accomplish is that we protect the taxpayers and that we don't have these cases going on. And we do give the discretion to the judge because the judge can take on all the factors in that case to ensure that this public records request or this entity is being kept honest.
Well, what if this leads to a slew of other actions, like federal actions? Because now that the attorney's fees can only come from a civil rights violation, people start claiming a violation of due process and start suing federally.